Now, obviously that changes with Dobbs versus Jackson Women's Health Organization. And it's worth talking a little bit about how Dobbs gets to the court, right? The court's composition changes radically after 2016. Neil Gorsuch is added in 2018. Brett Kavanaugh is added as well. Still a 5-4 conservative majority, but a bare conservative majority. And many people don't know where the Chief Justice will be. His institutional tendencies, as we saw in June Medical Services, led him to side with the liberals on the question of abortion, at least in June Medical Services. But everything seems wide open. Mississippi has passed a law, HB 1510, that prohibits abortion at 15 weeks. This law, under the extant jurisprudence, Roe and Casey, is patently unconstitutional. It's immediately enjoined in the lower courts and at the Fifth Circuit. Mississippi petitions the court for certiorari. In its cert petition, Mississippi says it's not asking the court to decide a big question, just trying to figure out whether a pre-viability ban on abortion is constitutional. Is the viability line, that 23-week marker, is that still a salient part of the court's jurisprudence? Very minor question, Mississippi says. That's when they file their cert petition. After they file their cert petition in September 2020, Justice Ruth Bader Ginsburg passes away. In October 2020, Amy Coney Barrett, a judge on the Seventh Circuit, is added to the Supreme Court to fill Ginsburg's seat. Now, instead of a bare 5-4 conservative majority, we have a 6-3 solid conservative supermajority. And suddenly, Mississippi is asking a different question. The court, over the period of almost 20 conferences, debate whether to take this case. But after the court's composition changes to a 6-3 conservative supermajority, they grant certiorari in Dobbs versus Jackson Women's Health Organization, but they only grant cert as to one question. And the question is this: whether a pre-viability ban on abortion is constitutionally permissible. No other questions are entertained. Now, Mississippi, after the court has taken certiorari in its first brief before the court, doesn't seem to be fettered by the fact that only one question has been taken up. They not only ask the court to uphold Mississippi HB 1510, they go further in this first filing before the court to explicitly ask the court to overrule Roe and Casey. And so again, think about the differences in their litigation posture from time one and time two. Time one, it's a very minor question. Just tell us if viability is still the marker. Time two, uphold this law and overrule Roe versus Wade and Planned Parenthood versus Casey. Nothing else has changed except the composition of the court. The court hears oral argument on this case in December of 2020. In December of 2021, and then May of 2022, we get a leaked draft opinion, which sends the entire media into a complete, and the Twitterverse into a complete tailspin. On June 24th, we finally get the final opinion in Dobbs. So that's the majority opinion, and then a series of concurrences and a dissent. And it's basically what the leaked opinion offered. There are very few changes between the leaked opinion and the final draft majority opinion. The majority of 5, or a majority of 6, upholds Mississippi HB 1510 6-3, but in a 5-4 vote, they go further to overrule Roe and Casey. They argue in overruling Roe versus Casey that this outcome is demanded because there is no explicit right to abortion in the Constitution. And they canvass quite a lot of constitutional text, again, selectively, because one could argue that the 9th Amendment, which says that everything that is enumerated is not intended to disparage the prospect of unenumerated rights, is not discussed at all, nor is the history of the 14th Amendment discussed. And the 14th Amendment was drafted in the wake of the American Civil War with a purposefully and consciously abolitionist ethic in mind. Right? The 13th Amendment abolished slavery, the 15th Amendment enfranchised African American men, and the 14th Amendment was intended to provide to these new citizens all of the vestiges of freedom by eliminating the vestiges of enslavement. And so what were the vestiges of enslavement? Well, the drafters of the 14th Amendment debated this, and core among them were the fact that slavery meant you had no control over your body, not just your labor, but the fact that you could be compelled to carry a pregnancy to term. Pregnancy or slavery meant that you had no control over your children. They could be sold away from you at any time. Slavery meant that you were ineligible for civil marriage. You could not enter into a recognized marriage. And so again, there is a line of substantive due process cases all interpreting the liberty clause of the 14th Amendment in ways that accord with that understanding. Meyer versus Nebraska, Pierce versus Society of Sisters, the right of parents to raise their children in the manner of their choosing, responding to that idea that that's a core aspect of liberty because it is the antithesis of enslavement. Loving versus Virginia, 1967, the right to marry the person of your choice. Obergefell versus Hodges in 2015, again, reflecting that the choice of a marriage partner is an essential aspect of liberty, the antithesis of enslavement. And then again, Roe, Eisenstadt, Griswold, the idea of reproductive freedom being a core aspect of liberty because it was something that was absolutely denied during enslavement. All of that goes unmentioned. And instead, the majority says that this is not explicitly articulated in the text of the Constitution, nor is it deeply rooted in the history and traditions of our country. Therefore, it's not a right, and Roe and Casey can be overruled. When the court talks about the question of stare decisis, that principle that so compelled the Casey plurality, it makes very clear stare decisis is not an inexorable command where past precedent is egregiously wrong, and Roe and Casey, the majority says, are egregiously wrong. The court has a duty and obligation to overrule it. And then Justice Alito goes forward to say that the logic of this decision is confined to abortion. It does not implicate any other fundamental rights